So shortly after receiving that affidavit, Mr. Keith Marlowe sends an email back to the debtor stating that I'm skeptical that your private lender is a real person. But even if they are a real person, I'm skeptical that they actually intend to pay off your debt. If your private lender is a real person who is interested in paying your debt, then I welcome them to pay the balance of the debt owing into the court or a trust account of a duly formed lawyer in Alberta. We can continue discussions if that happens. Now, obviously, that's a somewhat relatively reasonable request as long as it comes along with some reasonable conditions. Obviously, the purpose of a trust account is to keep money and hold them in there until certain conditions are met, at which point the money can be released from the trust to the individual that it was intended for. So, the debtor responds to Mr. Keith Marlowe with an email just stating, sure, my private lender would be more than willing to place the funds into a trust account as long as there are certain reasonable conditions that go along with you guys coming and taking that money from the trust account. So therefore, the conditions would be to release the money from the trust account. We must receive an affidavit of debt ownership. Once the funds are placed into the trust account, you will have 2 weeks to produce a sworn affidavit from a chartered accountant. The affidavit must confirm that your client maintains ownership of the debt and that the ledgers have been thoroughly checked to verify the matter. The second condition is the return of funds. If you are unable to produce the required affidavit within the specific 2-week period, then the funds will be returned to the private lender. As obviously, if the funds are placed into a trust and then the bank cannot fulfill the conditions needed to release that money, well, then the private lender shouldn't lose their funds. The private lender should have the funds returned to them. Third, credit restoration. Regardless of the outcome of the documentation request, my credit should be restored to the state it was in before we began requesting verifiable proof of debt. Due to the fact that the debtor had arranged the funds, he did not default. He didn't miss any payments. He was attempting to pay the bank out in full, and it was the bank that could not produce the proper documentation. So why should the debtor's credit be affected when it's not their fault that the bank is incredibly disorganized and cannot produce proof of ownership of the debt? And then 4, finally, responsibility for fees. Should the requested documentation not be provided, well, then your client will be responsible for recovering any expenses, including fees incurred in the process of placing the funds in the trust, which again is a very reasonable condition. At which point Keith responds, your conditions are not acceptable. Without any explanation or any reasoning behind his stance, he claims that those conditions don't align with his client's best interest, which is interesting. We're all curious as to why those reasonable conditions would be so intimidating to your client. So at this point, the debtor responds to Keith and says, hi, Keith. You've rejected the reasonable conditions that the lender and I proposed for depositing the funds into a licensed lawyer's trust account, as you had suggested. This raises a critical question. What was the purpose of the trust account if no conditions are imposed on the entity collecting the funds? Under what conditions do you propose Capital One should be allowed to collect the funds from the trust account? It's obviously very unreasonable to expect anyone to deposit funds into a trust account without requiring that the collector prove they own assets for which the funds are intended. The issue here is not whether or not the private lender has the ability or intention to pay off my debt, as you have rejected every effort we've made to demonstrate his capability and intent to do so. The real question is whether your client is legitimately entitled to these funds. For clarity, I would like to know who from Capital One you propose will complete the affidavit, and what steps they would take to verify Capital One owns the debt. Additionally, how do you intend to address the obvious conflict of interest that would arise when an entity from Capital One decides to make such statement, rather than a chartered accountant who's governed by a third-party agency, which prevents them from being any conflict of interest when inspecting creditors' ledgers? And finally, it is clear that you have a particular issue with the idea of a third-party chartered accountant, which is not in a conflict of interest, inspecting Capital One's ledgers. I'm curious to know why this makes your client so uncomfortable. At this point, Keith did not respond because he has no reasonable response he could possibly give to this. First, Keith slandered the debtor and the private lender by stating that they were running some sort of scheme and that the private lender did not exist. Therefore, the debtor had the private lender swear an affidavit assuring his existence and his intention to pay out the debt in full. Secondly, He suggested that the debtor place the funds into a trust account. The debtor agreed, sure, under these reasonable conditions, at which point Keith came back and said absolutely not. He's suggesting that there should be no conditions imposed on Capital One in order to collect the funds from the trust account. So that would make absolutely no difference. The private lender might as well just forward Capital One the funds without seeing the verifiable proof of ownership of the asset that they are forwarding funds for. So here we have Keith Marlowe just fabricating this rhetoric that the private lender is completely made up. And then when he's given direct evidence contradicting that rhetoric, he just wants to cover his eyes, keep screaming, this is a scam, the private lender isn't real, even though the private lender has sworn an affidavit, sent him multiple emails, agreed to put the funds into a trust account under certain reasonable conditions. So these are the type of entities that we're dealing with in debt dispute litigations. These bank lawyers have absolutely no integrity. They just want to cover their eyes and ignore evidence that doesn't help them and fabricate rhetoric that absolutely slander legitimate private lenders and Canadian debtors exercising their rights under legislation. In what world is it reasonable to expect anybody to forward funds for an asset that the seller refuses to prove that they own? In any other transaction outside of finance, a lawyer would tell you that this raises huge red flags. As soon as you step into the realm of finance, if you decide to use common sense standard business practices and confirm ownership of assets before you forward funds for them, you're looked upon as some kind of scam artist. When in fact, oftentimes allegations are actually admissions. It's very clear here that Capital One cannot prove that they own the debt that they're attempting to collect on. And Keith Marlowe here has set himself in the middle and fabricated some lies and some rhetoric in order to aid Capital One in defrauding the Canadian public. In other words, collect on assets that they no longer own. And that is fraud. That is a scam. So as you can see, it's becoming increasingly obvious that Keith Marlowe is in the middle of facilitating fraud on behalf of Capital One. Capital One very clearly cannot provide an affidavit from a chartered accountant stating that they still own the debt due to the fact that they must no longer own the debt. Otherwise, there would be absolutely no fathomable reason that a large financial institution couldn't simply have a chartered accountant check their ledgers and confirm that they maintain ownership of the debts that they're attempting to collect on. As you can see, the web that Keith Marlowe spins to try and get around that makes it very obvious. That's the only reason Keith Marlowe is present in this transaction, is to keep the debtor from getting their rights as a purchaser within a commercial transaction and pressure them to forward funds to an entity that can't prove they own the asset that funds are being forwarded for.